Good morning, everyone. Welcome to the fifth day of the FDP program organized by Ministry of Education's Innovation Cell and AICTE in collaboration with Assam Downtown University. Today is celebrated as World IPR Day. April 26th was chosen as World Intellectual Property Day because it coincides with the date the World Intellectual Property Organization, that is WIPO, convention came into effect in 1970. WIPO's member states designated this date in 2000 to raise global awareness about the importance of intellectual property and its role in innovation and creativity. WIPO, or the World Intellectual Property Organization, is a specialized agency of the United Nations responsible for administering intellectual property matters globally. Its mission is to promote and protect IP rights, encouraging creativity and innovation while contributing to economic, social, and cultural development. And today's session is all about intellectual property for startups. It will be taken by Dr. Pankaj Kumar sir and Mr. Manas Burman sir. Dr. Pankaj Kumar sir is the DPIIT IPR Chair Professor at the National Law University and Judicial Academy, Assam. With a multidisciplinary academic background ranging from biotechnology to law, he holds a PhD in biotechnology and LLM and is a qualified patent and design agent. Dr. Kumar Sir has extensive experience in intellectual property rights, education, and research. He has served in academic and policy roles, including as legal officer at FISME and assistant professor at IIS University, Jaipur. His contributions span curriculum development, IPR awareness, and scholarly publications on traditional knowledge and biotech patents. Recognized as an innovation ambassador by AICTE and recipient of the CSIR Diamond Jubilee Award, Dr. Kumar Sir is a dedicated advocate for innovation, legal education, and inclusive growth through IPR. Now let me introduce to you Mr. Manas Burman sir. He completed his BTech in mechanical engineering and worked in the corporate sector for a few years. He then pursued LLB from Campus Law Center, Faculty of Law, University of Delhi, followed by an LLM in intellectual property rights. After gaining experience practicing law in courts in Delhi, he now primarily practices in courts in Guwahati. In addition to this, he works as an IP attorney at IP Constellation and serves as an adjunct faculty member at National Law University and Judicial Academy, Assam. I invite Dr. Sunandan Barua sir to felicitate Dr. Pankaj Kumar sir and Mr. Manas Burman sir with a Fulam Gamusa and a memento. Sir. Thank you, Dr. Barua sir, for doing the honor. I now request the respected resource persons to carry forward the session from here onwards. Sir, the stage is all yours.
Oh, oh, good. Oh, oh, thanks. Good morning, everyone. First of all, I'd like to extend my gratitude to Assam Downtown University for inviting me here and share my insights from intellectual property. Today is a significant day for intellectual property because today is observed as Intellectual Property Day. And therefore, I really thanks the whole team for extending such a warm welcome. So I'll start my presentation basically on the aspect which is being given me today is intellectual property for startups. So I will try to channelize my presentation towards startups and what are the action plans and development plan that we can do for startups. So before we understand, first we have to understand why a intellectual property right matters for startups. Nowadays, as we see, intellectual property has actually taken a very important role in our daily lives. Today, people are more aware of why intellectual property rights has to be actually be taken care of. So basically, IPR are legal rights granted over creation of mind. They provide exclusive ownership and control over intangible assets. IPRs include patent, copyright, trademark, design, and trade secrets. And there are a lot other aspects such as the geographical indication, or let's say there's a semiconductor. And there are a lot other aspects in intellectual property rights. It also creates or owns to prevent unauthorized use, reproduction, or distribution of their works. And these are actually a strategic business tool for enhancing industrial competitiveness. So if we know intellectual property rights, other than the right property, for example, if we see property that we can see tangible assets such as we can see a car is a tangible asset, land is a tangible asset, but intellectual property rights as such is not tangible. It's an intangible asset. It's a creation of mind. Therefore, it is very, very important. We may not know. For example, we have created a song. Now, that song, for example, or we have written a poem. Now, if that song is something which cannot touch and feel, but that song, for that example, today in the Bihu season, the singers are earning a lot of money by singing a song repeatedly. As we quintessential song of Zubin Mayabini, he will sing in every function, and it's such a nice song to hear. But the question is this: that what if someone tries to earn money over that song? What if, let's say, that song is uploaded in the YouTube from a different channel, and that channel is actually earning money? Now, let's say if I have a water bottle and I start in Assam starting by the name of Bisleri, the question is that I am overriding, I'm having a goodwill, I'm trying to earn from the goodwill that the Bisleri has earned. So, therefore, it is very, very important to protect our businesses and the intellectual properties that we have. So now if we see why are IPRs crucial for startups? Because startups often start with limited resources, rely on continuous innovation to sustain themselves in a competitive environment. So as we know, startups is, if we see startups, they actually most of the time, until and unless there's a funding, they always start with a limited resources. Limited resources can be funds, can be human resources, and any other aspect. So basically, protecting IPR is crucial for this growth and development oriented innovations. IPR protection enables startups to preserve and exercise unique and differentiate product or service offerings. And it also enables to startups to preserve and exercise unique and differentiate products or service offerings. Now, if we see, let's say today we have a lot of startups. We have, let's say, Zomato, we have Swiggy, let's say we have Ola, Uber. Now, how will we differentiate what services Swiggy is offering versus what services Uber is offering? So until and unless Uber now has a brand name, for that matter of fact, Ola has a brand name, for that matter of fact, So now I will deal with two aspects of IPR in my session. So the two most important aspect is the trademark and copyright. Now, the concept of trademark is a fundamental concept of intellectual property. It is basically a distinctive sign or symbol that distinguishes a company's product or services from others. Now, what is actually a trademark? Many a times it is very, very difficult to delineate, or let's say to segregate the kind of intellectual property rights that are there. For a startup, it is very, very difficult to segregate what are the different kind of intellectual property rights. Many a times, let's say this is a phone of OnePlus. Many a times the startup will come to us and say that I want to patent the name of OnePlus. Is this possible? Can we patent a name? Therefore, it is very, very important to understand what is actually what is the kind of intellectual property right that should be secured by us in a startup, or let's say in any businesses. So therefore, trademark can be of various forms. So basically, if we see trademark, now whenever a child is born in any society, so the first thing that we do for that child is to give them a name. But mainly in Assam or Northeast, I have worked with businesses where they will say that, sir, we'll do the trademark application after our business is like, it gets spread it. Now, if the business is not, if business cannot be distinguished, let's say you're selling a bottle of pickle. Now, if the person cannot distinguish that pickle is from, let's say, Manas company, and they like the taste of the pickle, and if they cannot distinguish it, the question is, if they like the bottle of pickle, and then how can they go to the market and ask that I like that bottle of pickle and give the Manas company pickle? So therefore, it is very, very important to first give a name to our businesses. So trademark, if we see, can take various forms. First of all, trademark can be logos. So many times, let me see the half-bitten apple in the Apple phone. So that can also become the logo that the Apple has becomes a part of a trademark. It can be word mark also. Let's say today Coca-Cola, for that matter of fact, we don't need to see the logo of Coca-Cola. One just have to tell the name, and you can get the idea what a brand name is. So basically, it can be logo, brand, name, slogan, symbols, picture, packaging, sound, smell, and shapes. So even today, sound can be also be a trademark. Let's say the quintessential example of the Nokia phone. Whenever you used to switch on the Nokia phone, there used to be some sound to it. So that can also be got under trademark. Now, with a perfume, for that matter of fact, if we see today, there's some certain kind of a smell that is there in a perfume, let's say, and that we attach to, and that can also become under trademark. So if we see words and designs, so Disney, if we see, is a very important, is a very well-known trademark. So trademark can take two forms. Now, let's say, for example, today Coca-Cola is called as a well-known trademark. Now, if I, let's say, have a phone of Coca-Cola, everyone will think that it's a phone from Coca-Cola, because the way the Coca-Cola is there in every country. So therefore, if we see words and design, Disney, for that matter of fact, is just a name that has been given as a trademark. And if we see, there is certain distinction. There is white letters over a blue background. So Disney has tried to actually done two kinds of trademark here. First of all, they have got a word mark. Word in the sense Disney. So they can take a trademark of the name Disney, and they can, if they get the name of the trademark, they get the trademark of the name Disney. So basically what happens, they can use Disney in any manner. Let's say tomorrow they can write Disney in different kind of a setup. They can probably write Disney over a red background, or black letters, white background. So basically, if we get a word mark for our trademark, so we can have wider rights to us. But however, if we give a logo to it, let's say for example half bitten apple that we use in Apple phones, so therefore the moment we see this symbol, we immediately attach the fact that it must be some product from the Apple company. Now there can be slogans also. Now now if we see the word thanda matlab, what does the next thing that comes to our mind when we say thanda matlab? Coca Cola. So if we see thanda matlab, the moment we say it, the word that comes to our mind is Coca Cola. The reason is why, because they have attained a distinguishedness. It has become a distinguishing mark for them or a slogan for them. So if you see in McDonald's, there's a word called I am loving it. So the moment we see McDonald's, I'm loving it, the immediate thing that strikes in a mind that it should be from McDonald's. So therefore, now if someone, let's say thanda matlab Coca Cola, now if let's say Coca Cola tomorrow does not secure its rights, for that example it does not secure its rights in the sense that it does not protect rights, someone, let's say thanda matlab Kempa Cola, it becomes, nowadays Kempa has become famous. If tomorrow thanda matlab Kempa Cola has become, so therefore what happens, our mind will be confused. Our mind will be confused in the sense that thanda matlab Coca Cola tha pehle, now it is Kempa Cola. So therefore, it is very, very important that Coca-Cola should secure its rights. It should secure its rights under the IPR law, that what they have developed. Then there is something called as Mountain Dew also. Dar ke aage jeet hai. If dar ke aage jeet hai becomes Kempa Cola, the problem is that the goodwill that Mountain Dew has created for over this period of time, that will go in vain. And therefore, how to secure these rights? So there are two ways. Either we register our trademark, we register that slogan. So once we register that trademark or a slogan, so once you get the registration of that, let's say slogan or a mark, so anytime a different company try to do that, so what happens? So you can file a case against them, and only then that will create a demotivation for them to, ride on our goodwill. Then secondly, colors. So Cadbury, for that example, something which we relate from our childhood. That moment we see there is a violet mark over the written as Cadbury, then we see that it must be from a Cadbury chocolate. But many a times you will see in the market, what they'll use violet and white letters, but Cadbury will be written in such a way, like for example Bisleri, many a times when we buy a bottle, after we drink the bottle of water we find out it was written as Bilseri, not Bisleri. So they will try to deride our goodwill. So many a times hardly any customer will see that whether it is I is written after L or L is written after I. So they will automatically buy Bisleri or Bilseri. So therefore, we have to very, very important that if any company is trying to make the similar kind of a green bottle written as Bilseri instead of Bisleri, it is very, very important that we secure our mark. And therefore, that can be only be possible that can be better possible if we try to secure our mark by registering our mark. Now it can be shapes also. Let's say we have a candy. If you see, candy can have different shape. So shape can be also given a mark. So for example, let's say there are some color, multicolors, then there's a rabbit symbol. So basically shapes also can come under the ambit of trademark. Now, when we try to register our mark for a startup, it is very, very important. Capacity to distinguish. Your mark should be able to, one should be able to distinguish the mark. Now, let's say, if we try to, let's say tomorrow, let's say make a mark let's say take an example of let's say we take an example of OnePlus. Now I am a new startup who is trying to make a manufacture a new phone under the name of OnePlus Plus. So now if we see, if we try to make a new brand with the name of OnePlus Plus, and there is already a company which is named with OnePlus, so what happens? I am not being able to, people will not be able to distinguish my mark from the other mark. So therefore the test in trademark, it is very, very important in the courts, because I started my practice in Delhi High Court in the IPR division. So basically I started my practice as an IPR lawyer. So I must tell that if startups are not vigilant about getting their trademark distinguishable, cases will be filed against you by huge corporates, and it is not very easy to defend. I'm defending few startups, and it is very, very difficult in courts, because the corporates have all the resources to clamp down upon a startup. So a startup will focus on legal cases, or a startup will focus on actually securing their better businesses. So therefore, if we have to, there's a test called as a man of average intelligence and imperfect recollection. This is a very technical word. So if we have to distinguish between two marks, the test of average intelligence and imperfect recollection is something which is a test which is propounded by the court. So if you file a trademark, so the journey of a trademark first starts with filing a trademark. Now, many times we have seen a lot of people have using, let's say, marks which is like used as an emblem. Let's say I have tried a mark. Let's say if I file a trademark with Gamusa symbol in it, will I be given the trademark by the trademark registry? No. The reason is this: because Gamusa is being used in common parlance. But however, if I used Gamusa along with other symbols which can be distinguished, then the trademark can be given. So categories of absolute grounds of refusal. So it becomes a little technical in a lawyer's perspective. So there are two ways when a trademark can be refused. One is the absolute ground, then the other is the relative ground. So what is the absolute ground? Non-distinctive. Let's say I am trying to make a mark, let's say of letter 7. So it cannot be distinguished, right? But if I write as Cafe 7, Cafe Guwahati 7, or Cafe, let's say Pani Khaiti 7, so then one can distinguish, okay. But now if I remove everything and write and try to give a trademark of only cafe, then it will not be distinguishable. Descriptive. Now, let's say, for example, instead of giving this name as OnePlus, I give my company's name as mobile phone. Now, everything is a mobile phone. Even an Apple mobile is a mobile phone. Even a OnePlus mobile phone is a mobile phone. Oppo is a mobile phone. So therefore, the name should not be generic in nature. It should be distinguishable. Generic. So basically, many a times what happened, aspirin. Aspirin is a drug. So basically, if you try to get a trademark for the name aspirin, the problem arises. Contrary to public policy or morality. So one should keep our name. So if let's say someone is trying to get a trademark of a slang word, that would not be given. So that is absolute ground. Likely to deceive the public. So if I try to get a trademark of Bilseri registered, that will likely to deceive the public. A public will not be able to distinguish, let's say average public, let's say public which are not educated, will not be able to distinguish whether it's a actual Bisleri or it's a Bilseri. So therefore, it is very, very important that it should not deceive the public. Prohibited by law. So state emblems, national emblems. Someone have also tried to give a trademark of Ashoka Chakra. So that is being this thing made in bad faith. What can be bad faith? Let's say, for example, someone is trying to make the trademark of Bilseri. That can be bad faith. Relative grounds for refusing to register a trademark. So relative grounds can be Like, that is the test call is a man of average intelligence and imperfect recollection. Now, trademark infringement. The proprietor of a registered trademark has exclusive rights in the trademark which are infringed by the use of trademark in given territory without his consent. Now, let's say today, Harvard University, someone tried to establish by the name of Harvard University in Assam, or let's say in India. Will people not be likely to be confused that it is a Harvard University from US? People will likely, if there is a Oxford University, by the way, we have Oxford Academy of School and all these things, and many times there's a school I don't want to name in the public forum which had to change their name in Guwahati. You just find it out, there will be. Yes. Yes. So therefore, schools had to change their name. So those are the things we have to be. So many a times what happens, let's say the kind of, if we are a startup, let's say I have just opened my venture, and the money that I send in my branding or let's say advertisement, if I'm not careful whether that mark will be deceiving or not, so what happens, all my money goes for waste. So if you see Sarma Sweets, how many Sarma Sweets are there in Guwahati? I guess there are numerous. Every, I guess, gully has Sarma Sweets. In North India, we have something called as the Jaljira. There is one Jaljira, Jain Chikanji. Anyone heard about Jain Chikanji? So from Delhi Meerut Road, you'll get Jain Chikanji in every stop. But the actual Jain Chikanji has actually diminished. Because why? Because Jain Chikanji has not been able to secure their trademark. So basically there are two things. Now many a times businesses don't register their trademark. Okay, let's say there are many businesses which are from many years ago. They're not registered their name. Okay, I guess there are many benches in Guwahati, in Assam. Let's say for that example, let us see the example of Bazoi Hotel. You know about Bazoi Hotel? How many Bazoi Hotel are there in Guwahati, and how many of them know that they are from which one is the main branch or which is originating from Kokrajhar or Guwahati? But ma'am, the question is that how many of you know that the branch of Kokrajhar, the main branch which is there in Kokrajhar, the sub branch in Guwahati, which is the Bazoi here in Guwahati? We hardly have any idea, because the reason is very simple, because Bazoi Hotel has not secured the trademark. Few people know. I was born in that place. I know that which branch of Bazoi Hotel in Kokrajhar is it there in Guwahati. But once they secured the trademark, they would have secured the trademark and say that if you're using that name, you cannot use that name. So that is the benefit of registering the trademark. Once you register the trademark, your name is in the trademark registry. So once your name is in the trademark registry, so what happens? So the betterment that can happen is that there is a prima facie proof that yes, your mark is registered and you are the bona fide user of the mark, and you can ask anyone else that don't use this mark. Okay, and even if that happens that they are using that mark, there are things that I'm coming in the next slides you can do to actually ensure that your trademark is not being used. So that is called as the infringement of trademark. So in lawyers parlance, we tell two things. One is the passing off and one is the infringement. I'll not go into so much technicalities here, and I'll keep it simple. So invalidity and revocation. So if a trademark may declare invalid if it is registered in breach of one absolute or relative grounds. So many a times what happens, I have faced lot of people, what they do, they go and register the trademark without doing a proper search. So after that, what happens? After that, they will get objection from the registry, and thereafter what happens, that the mark ultimately doesn't get registered. So I will come to my slides where I have told what are the things that has to be done before registering a trademark. So importance of trademark in startups. So basically, they establish brand recognition and differentiation in crowded markets. They protect a company's brand and reputation. Now, let's say, for example, I have seen a business called as Repose Bakery. Repose Bakery is very famous here in Guwahati and in many other places. So I see that they have, or let's say, Loyan's Bakery. So if Repose Bakery would have not secured that mark, what would have happened? Anyone could have used the mark like Bazio Hotel. Anyone could have opened a Repose. Loyan's Bakery. Now, many a times we go to buy a cake, let's say in the Loyan's Bakery, a very place where we sit near the court. So therefore, it is very, very important that one should secure their mark, because if we see there's a particular taste, let's say we'll say that the sandwich in Repose Bakery, let's say the paneer sandwich of Repose Bakery is better, or let's say the chicken sandwich of Loyan's is better. So therefore, if we try to distinguish it, only then we can secure our trademark. Then trademarks are valuable asset for startups. They enhance the perceived value of startups. Unlike registered names, only a trademark provides proper legal coverage. If ignored, not utilizing a trademark can affect an organization reputation and business and lead to huge losses. Safeguarding trademark. So if we see nowadays, I'm telling from the perspective of law a little bit here. So how many of you know about data protection bill in India? There's something called the data protection bill. Nowadays, if we do businesses in, let's say, in European Union, there is something called as GDPR, General Data Protection Rights. So if you're not compliant with the general data protection rights, they will not allow you to do business in Europe. Similarly, nowadays what has happened, how many of you have been victim of buying a fake branded product online? Let's say got a fake Adidas product in Amazon or Flipkart. Anyone has been a victim here? Got a fake product? Got a fake product? Right. Now what happened? Many a times, so if we see Adidas, Nike, or let's say all these famous brands, there will be counterfeit products which are being sold through Flipkart and Amazon. Nowadays, what has happened? There were cases being filed against this company saying that Amazon is producing, Amazon or let's say Flipkart, all these e-commerce company are promoting fake products. So what Amazon, Flipkart are doing is this, that Amazon, Flipkart, what they're doing is this, that they are actually now asking that if you are a seller and selling a product of a known brand, or let's say whatever brand you're doing, there should be a registered trademark certificate in that name. Without that, we are not allowed to do business. I have myself seen few cases in Delhi High Court where anyone knows the drug named Combiflam? Combiflam in name? Painkiller. There are companies which have tried to make the same drug with the name of Comziflam. So therefore, what happened? Pharmaceutical companies, if let's say nowadays a lot of pharmaceutical companies are coming to us for registering their trademark. The reason is, let's say there are a lot of companies like as 1mg online. Nowadays, once if the drug name is not being trademarked, one cannot sell their products online, or they cannot name their product online. Then there is something called as a very, very famous kitchen there is in Guwahati also. There's a case that is going on which is related to chicken, non-veg, Karim's. Actually, that case is going on Delhi High Court. So if we see the actual Karim's that is in Chandni Chowk, if anyone has the opportunity, and the Karim's that we see in other places of Delhi, they're different. If you see to Karim's in Chandni Chowk, there will be a board written, we don't have any other branches. Correct? But the reason is that they not have been able to secure the trademark. The only thing they are doing out right now is that saying that we don't have any branches, like a public notice. So first thing that we should do for securing a trademark is conducting a true trademark research. Now, let's say, for example, in India, when we, let's say, when you give a name for our, let's say, when you gain a name for our children, let's say we see a lot of things. The date on which he was born, the time when he was born, all these things, Gotra and all those things, chart and everything. Many times we consult numerology and so many things and many times we change the name. So Giving a name to child, we see a lot of things. So similarly, we should also try to see there are things which we should do before registering a trademark. The first thing that we should do is to do a thorough search. And I'm telling you from my limited experience that there are companies which have just registered their trademark without having a proper search. There's some name came in their mind, registered a trademark, the registry gave an objection. Now I advise them that you cannot go ahead with this trademark. Reason is because there are already similar names which are there in the market and registered. The trademark registry will not give you the trademark. So all that I've told them that you get a new mark, or let's say get a logo for it. So a thorough search before getting a trademark is very, very important. File for a trademark registration. So basically this is crucial to secure exclusive right and establish legal presumption of ownership. Now, many times what happens, trademark is not necessary to be registered. If you can show that you have been in the market for a long time, or let's say you can establish that I am doing this business from a long time. But the question is this, to establish that in court will be a very, very difficult process. So the easiest process to secure a trademark is to get it registered. Nowadays, there is something called as the government scheme called as the scheme for facilitating startups intellectual property protection called as SIPP in India. So if there is a startup, so the fees for filing a trademark, patent, copyright, whatsoever, the fees is straightly 50%. So if the official fees for filing a trademark, if you're not a startup, is 9,000 rupees for a single application, and the moment you can file, if you get the certificate of MSME, that is the Udyam certificate, the fee straightly comes to 4,500. And many a times the government is what they're doing is this, that let's say there'll be some attorney fees also. Let's say I'm also a trademark attorney, I'll charge some fees to actually file the trademark, because I will also do a lot of background search. Then there'll be hearing also, there might be objection also. So the fees that I'll charge, so that is also reimbursed nowadays up to 10,000 rupees if you're a startup and the marks get registered. Step 3, use appropriate symbols. So many a times if we see that word TM, so if the trademark registry does not give the mark as a registered mark, so we are only entitled to use the word TM with your mark. But the moment it is registered, we can use the word R in the circles. Now if we use the word R inside the circle, it has happened. Many a times what has happened that people think that if I file my application, it is registered. So they start using the word mark R, and therefore it is not permissible, and there are penalties also for using the mark without getting the mark registered. Then step 4 is vigilantly monitor and enforce. Now many a times it is very, very important. So once we get the mark registered, let's say it has attained some kind of a distinctiveness in the market, it is also very important that we should be actually vigilant and actually stop anyone from using that mark. Step 5 is address infringement promptly. So many a times people will use your mark if it gets a distinctiveness. Let's say Repose Bakery, someone will try to make it a different name. Loyens Bakery, someone will make it a different name. So if they're infringing our mark, so we should also take those steps. For example, let's say in trademark, in our IPR law, we call it a cease and a desist letter. We tell them you cease using the mark and desist from using this mark forever. It's like a legal notice. Now, concept of copyright. So copyright is different from little bit from trademark. Yes. NIT, yes. 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 A very good question. So basically, in the Trademark Act, we are not being allowed to use some government names and emblems. So these are institutes which are being established by the government, National Institute of Technology, Indian Institute of Technology, Okay, so therefore those marks cannot be used at all. Let's say for national law of university. So those things, and many a times now the trade. So many a times what has happened, lot of times it's correct. So many a times what they will do, that Indian Institute of Technology, they will name it as Indian Innovation Technology instead of IITs. But therefore, the moment one will use Indian innovation technology, let's say for example there is IIT. Let's say in a place where there is not much of awareness, they will use as Indian innovation technology. So what will happen then? Because IIT has not got their mark registered, but the moment it is a government name, and secondly, when you are trying to deceive the public, so basically the government itself will say that you cease using that mark. And moment, let's say for example Indian Institute of Technology, if Indian Innovation Technology, they will try to get their name actually get some recognition from the UGC or let's say AICT. From moment there only they will be stopped from using that mark if it has to get recognized. So nowadays what happens, for example, when you try to register a company, so they will always see that whether your name of the company is being in conflict with any other names or not. And therefore for all those government names, emblems, symbol, it is prohibited under the Trademark Act. Therefore for the government it is not necessary to secure a trademark of the name. As I said, Ashoka Chakra, many a time people have put Ashoka Chakra in their trademark and it has got registered. That is prohibited by the fact that it's a government emblem. Did I answer your question? Yes, sir. Thank you so much. So copyright is a different, because it is protects original work of authorship. This includes literary, drama, musical and artistic work. Let's say someone has given a painting. Let's say there's a painting that is made, that is a creation of someone. Now let's say someone has written a drama, someone has written a poem. So what happens? Let's say the book of Lokminath Bezborwar today, he has died, but there are a lot of other authors also today. Now if, like, let's say tomorrow what I do of a very good author, I give his poems, I make a compilation of a book with all his poems as it is and try to sell it. What am I doing? Someone has given all his efforts in his life only to write those poems or let's say those articles, and I have done nothing, no application of mine, just copy paste, make it in a book and sell it. So therefore that should not be allowed. How will we protect it? So basically all this aspect is taken care by copyright. Now for example software codes, now we call it something as an app, right? Swiggy works in a different way, Zomato users works in a different way, Ola works in a different way. So there are software codes. So therefore those software codes cannot be patented, those software codes cannot be trademarked. So those software codes, what that can be done? Anyone from IT sector here? IT engineering? You're from IT engineering, sir. So softwares, for that example, if they are, let's say Tesla for that example, if the software is giving some hardware output, then that can be patented, which sir will deal with. But if the software, let's say for example, I'm making an app, Ola, Uber, Bulaga, Ola, Uber. Ola, Uber is by the way, today the largest cab company doesn't own a single cab, Uber and Ola. They are only building the application. And if those application, those codes are so important, if anyone could have made it, there must be a lot of names, no, in the market. Prime cabs, what cabs, this cab, that cab came and went in the market. Because what happened, that this Uber, the way they have worked in the platform, the software codes, they have actually tried to secure it. Because if we mirror that, it is not very difficult to reverse engineering the software codes. It is very easy, reverse engineering. Because I'm also an engineer first, then a lawyer. So therefore, reverse engineering in mechanical engineering or any kind, reverse engineering is a very easy way. In India, what we call as the Indian jugaad, reverse engineer the thing and then make it. So therefore, it is very important. So let's say there is a song or there is an artistic work, there's a logo made. So therefore we have to be very, very careful. Those comes under the copy of copyright. So what we call in the copyright is called as a works. So what is a work? So what comes under the ambit of copyright? Let's say, for example, literary works, dramatic works, musical work, artistic work, cinematography works, sound recording, broadcast, performance. So all these things. So many a times we see in YouTube, we'll see nowadays that many a times that we'll see a video. Then after that, let's say those songs, famous songs, after some time it will be said that this this song cannot be played because it is now by struck under the copyright. It is very, very easy. Today what happens, this is a famous case that has gone in the Delhi High Court. Because I'm from Delhi High Court, I practice in Delhi High Court, so I can give some examples. So many times what happens, IPL, some people what they're doing, let's say for this is their IPL is going on here in this let's say in this laptop. What I'm trying to do is that I am just giving this mobile phone, video is on, and I am like broadcasting in my YouTube channel. I'm just doing this. I'm just taking the video of this IPL that is going on here in the laptop and giving a live video in my YouTube channel. And the amount of money that I'm earning is huge. But what is IPL losing? Because people are not visiting their channel. Advertisement will come only when there's a viewership in the channel. That's how YouTuber runs. So therefore, what has been done? Let's say domain name, for example. If I, let's say, take the domain name of Harvard University.in or .co.in, what happens? I'm actually trying to deride on the name Harvard University. So therefore, it is very, very important. Such kind of the works. Idea and expression. In copyright, it is the most important aspect is, it is not the idea which is being protected, but it is the expression of idea. So let's say I have a fabulous idea, but I have not implemented that idea. Then what happens? My copyright will not be protected. It's a very famous case from 1953 or 1957. I guess once I've also heard about this tussle going on between the producer of Three Idiots and then Chetan Bhagat, right? Then from before that, there was a very famous call as R.G. Anand versus Deluxe Films. So what happened? Let's say I am someone who has wrote a movie. The name was, I guess, Hum Hindustani, right, sir? Hum Hindustani. So what happened? Let's say, for example, I am a writer of a movie, of a play. I wrote a play. Now what happened? I was writing a play that, it should be like that, and all these things. Now someone, let's say, sir, has actually heard that from me, that play. Now sir has that, let's say, the capacity to turn into a movie. Now sir has actually, what has happened, the play that I had written, let's say in theaters in Assam, we write the play, how the play should be, they go around in Assam. So now what happens, I have written that play, I have written it, but I have not produced it into a movie. Now sir, what happens, sir now produces into movie. Now there's a difference. I had the idea, but the expression was not there in the form of a movie. And sir has actually expressed in the form of a movie. So what will be protected here? Can I seek copyright infringement against sir? Answer is no. Because it is not the idea, but the expression of idea. But one moment we can. Let's say sir will do some minor aberration in the movie. Let's say if I say that I went from Guwahati to Dibrugarh, sir will make it Guwahati to Dhubri. If I say that I went by flight, he said that he'll go by flight. He's gone by train. So some minor aberration will be brought and said that no, it is my original idea. So therefore, it is very, very important that one should not just have the idea, but expression of idea. So here is like we can copy as long now, in childhood we'll see earlier we used to get the movies in CD, and there was like CD pirated CDs over CDs. The pirated CD industry is actually killed the industry of CDs. So therefore, it is very, very important, not just copying. We have to, like, copyright is unlawful. Then there is a very, if someone is from Delhi University, will know. So the case of Rameshwari Photocopy Services versus Oxford University. So in Delhi University, what we used to do, so many times before exam, we'll go to the photocopy shop and asking what all we have to study, because the photocopy shop will know everything. And then they will say, you can, for if you have this exam, you can study this and this material. And buying a book was very difficult at the end moment. So what they'll do, they will say, we have a photocopy of this. That book will cost 6,000. He'll give us just 200 rupees. Now Oxford University filed a case against them, saying that you are reducing a book to a photocopy of 200 rupees. The original price is 6,000 rupees. Who will buy the book? Everyone will buy a photocopy. So therefore, what happened is this, that they filed a case, but however, there's an exception to copyright also. Let's say many times when let's say I'm using a slide today for educational purposes, or let's say when I teach in my class, I might have to bring some books, but they will be called something as a fair use. What is a fair use? If you're using for a bona fide purpose, let's say for an educational purpose, one can actually use that copyright, and that will be not be a copyright infringement. Exception and limitation, fair use. So basically fair use or dealing exception. So it is for research, or let's say private study, criticism, reporting, current events, or sound recording, broadcasting, copyright can be protected. Copyright in startups, I'll not go into it. It's like similar like in trademark. So step involved in protection of copyright, understand what is protected, creation provides protection, consider registration for added benefits. So I'll not do that. So now what are the strategy in strategies, trademark strategies and their effect on startup success? So first of all, for any trademark business, it is very, very important that to build a brand. Nowadays, everyone tries to build a brand. Lot of times in Swiggy, let's say for example, there are restaurants which are not there actually in market. They have something called the cloud kitchen. They're only selling through Swiggy. They're only selling their services online. So what they have done is that they have created a brand. Any startup that we know that has come in recent time, anyone has a name, like just 1 year back and has become very famous, or let's say 2 years, 3 years, any name that has become famous? Sorry? Zepto, Blinkit. So these have become very famous. Blinkit, we know that if we click on the app Blinkit, it will deliver the product to us in 30 minutes. So what is Blinkit known for? For delivering those grocery items at a very short time. So therefore, we should first build the brand value. Second is protection against confusion. Copyright infringement, where small business adopt established trademark, either exactly or in a modified way, making it difficult to be differentiable, it is determined by the likelihood of confusion standard. This is a significant risk for early stage entrepreneurs entering the market, and proactive trademark protection is the defense. So protection against confusion, and I'm telling from my limited experience that many a times there are business ventures which have tried to come up with a confusing name. The court has passed an injunction saying that, so basically let's say a remote business, I'm using with the name of BPL. So what the court has done, oh, you are now infringing the mark of a known company called BPL, so therefore I'll injunct you from not doing the business. So a startup which has just started, if they file a legal case, all the resources goes only for legal cases. From a lawyer perspective it is good, but for a business perspective it is not good. So therefore, the first thing that one should do is that they should get their names should not be visibly similar. Preventing loss of goodwill, infringement case cause damage to brand reputation. So let's say so disconnect two ways. Now let's say in IPR, many a times what happens, I have tried to, let's say in my cases, there are cases where even Google has filed a objection against registration of my mark. Lot of Louis Vuitton has filed an objection against registration of my mark of my client. Now, there are two things that can happen here. I can bleed money on this court, on this court, this thing, court procedures. But there's a good thing to it. There's a blessing in disguise in it. Can anyone guess what is a blessing in disguise in it of Google filing a company? Popularity. So if my name comes that Google has filed a case against it and becomes a known in the news, I, because of the court cases for advertisement which I had to pay money, now it will become famous because of Google will make me famous, and thereafter maybe I'll change the name. I'll say to the court that okay, I'll change the name. So many times I should not say in an open forum. Many times we tell the client that okay, let's take up this to the court and let us see. Then we'll also get a brand promotion here. Litigation. Copyright strategies, software and digital products for tech startups. Copyright protection of their software code, unique digital content. Then is fundamental. Now creative content. So we have a creative content. Let's say nowadays, for that example, there are a lot of informative videos that are there in, let's say, in the YouTube channels. So those creative contents should also be secured. Enforcement. So what are the challenges faced by startups? So startups often face challenge in protecting and enforcing IPRs due to limited resources, complex legal procedures. Startup may lack expertise in navigating IP laws, and the most important part, this is a study that was being done. It's a real study that was being done. That what happens, only 60 to 75% of businesses, they actually know what is the IPR that they have to protect. As I said, let's say the name OnePlus or let's say the name Vivo should actually be protected under the Trademark Act. Now they will come to us and say that, sir, can you please patent the name? So many times what has happened, they should get the protection under the, let's say, the Copyright Act. Then they will come and say that, sir, can we come under the Designs Act? So therefore it is very, very important that we should identify that what is the trademark that we are what is the trademark that we should file for. IP action plan for startup. First of all, the first action step is gain IP awareness and education, actively promote awareness and adoption of IPR, understand the different type of IP which are most relevant to a specific business and industry, utilize resources like information booklets, a government consultation. Now it is also, let's say for example, in any businesses, there can be multiple kind of a, let's say, intellectual property. Okay. Now let's say for this example, this mobile phone might have a name called OnePlus. Now this OnePlus should be what? Should be given a, should come under which law? Trademark. Now there might be some other things. Maybe the shape of the phone. If you see the phone, there are some cameras here. If you see, every phone has a different camera kind of a setup. So there might be some design aspect also. Let's say for example, I have bought this phone probably for the reason that it looked in a certain way, probably for the design also. Let's say we buy, let's say, a jewelry for the design. Everyone has a different choice. So we have also to secure that mark, let's say in the design. Let's say there might be some jingles. Thanda matlab Coca-Cola. Then what are there? Many businesses have their jingles. So what copyright protection that we should have? Then let's say this is a complex mobile. There might be some semiconductor circuits here. Semiconductor circuits. So that will come under the Semiconductor Act. Or maybe I might have done some invention here that will come under the Patent Act. So therefore in this mobile phone, there might be at least 5-6 types of IPR. So therefore it is very, very important that what is the IPR that you are seeking to protect. It is very, very important to first identify what is the IPR that you're seeking to protect. So third is conducting comprehensive searches. Action 4, prioritize and file for registration. So the moment we identify the name of our businesses, or let's say whatever thing we do, first of all that we should do is file for registration. But copyright, for that example, let's say mostly everyone is from academia. So many a time when you write a research paper, what are the steps that we do to actually protect our research paper? Do you take any steps to protect our research paper? It will come under copyright, but do you take any steps? Publication, correct? Let's say if the research paper, let's say sir is there, I stay with sir in the same house. I have seen that sir is writing on a research paper. What I do tomorrow is this, that I steal that paper from sir, research it and keep it in online. So what protection will sir have? Research not published is a research not done. But still, there is a way. So once there's a publication, sorry, pre-publication is there, but as ma'am has said, the research not published is a research not done, in the sense that one can have an idea. A research not published means that if you have that idea and that idea has not been expressed in the form of a publication, then that cannot be protected. Then implement internal protection measures. So let's say, for example, if you're trying to, many times, I guess, I'm touching on a little controversial topic here, co-authors in a research paper. Co-authorship in a research paper, I guess in academia, it's a very controversial topic. So how do we actually secure that co-authorship rights should be there? In patents also it is there. So in a research paper, how co-authorship, how it will mention, tomorrow we are co-authoring this paper in the same place and one of the co-author goes and publish and I don't get the credit. So what happens then? So therefore there has to be some measures taken. Maybe we go into an agreement. Maybe you have some written form, some written form that, okay, we are trying to co-author a paper. So copyright registration is not mandatory. Once it is published, the copyright is given to us. Then implementation internal protection measures. Many times there's a matter of trade secret which will be dealt by sir probably. So basically what happens that many times, let's say I guess we have that example, no? Coca-Cola has not patented their taste. Why? Because if you get it patented, they said it's for trademark, you have a right of, let's say, 10 years. So in a trade secret, what happens? It's a trade secret for you. So there is said, no, the makers of Coca-Cola don't meet on the same plane, rumors goes like this. So therefore, trade secret, what happens? You file something called a non-disclosure agreement. Let's say there is a research that is going on in an university. So therefore, the moment we do a research in let's say university, we write something called as a non-disclosure agreements. So those things has to be kept intact. Now, developing a monitoring strategy. Now, if you see big businesses, what they do, they have a monitoring cell. Like they will see, like how many of you have been using my name, or how many have been using the software. How many of you are from engineering background, like engineering faculties? Yes. So civil engineering, mechanical engineering, ma'am? Civil engineering, mechanical. So many times you use the software called as CAD. So I'm telling you, a lot of my clients have got notices for using a pirated version of CATIA or a CAD. And most of the people do use only pirated version only. So therefore, if you're, let's say, because all these big businesses have a monitoring setup with them. 7 is prepare for enforcement, seek professional guidance, and the most important step in IPR is make IP an ongoing process. So many times what happens, the moment we register a mark, or the moment we get the things patented, or the moment we get the copyright of something, we forget about it. So therefore, let's say for geographical indication, Gamusa for that example. How many of you know that Gamusa also comes from outside? Gamusa comes from outside, but we have a GI tag of Gamusa. That means that producers from outside Assam, or let's say who are the registered producers, sir and me went for actually to Thokwakhana to give registration certificate of producer certificates for Muga silk. But there are still Muga silk which come from outside. There are still Gamusa which will come from outside. Because we think that once we have registered the geographical indication talk of Gamusa, bus, matter is over. But no, it should be an ongoing process. There should be, because the moment we file a case against someone, once we get a GI tag of Gamusa, and if the moment it is manufactured outside, let's say Assam, then what happens? That is infringe upon the intellectual property right of Gamusa. So therefore, that's why IP is an ongoing process, and therefore these are the aspects which should be taken care of and should be very, very well segregated and lineated. And I must tell from my experience in IPR that IPR is one of the most dynamic aspects today. Every day there will be new jurisprudence. In our law, we call this as a jurisprudence. There's always a new way how an IPR has to be interpreted. And there is always a new way how new types of IPR are coming. So therefore, that is where we protect our IPR. Thank you so much. Questions? Okay, please. Questions now. There is no time limit, sir, with regards to trademark. But there is one thing that the earlier you do it, the better it is. Let's say, for example, all these big companies, whenever, let's say, they will give a new, let's say, they will when they will come with a new, let's say, car, for example. So they will get the trademark first, and thereafter they will come, they will launch it. At any point, and one can actually give it before even the production has started. One can actually go it before production has started. I've advised for company registration that I've done of my clients, I've advised that you get the trademark registration of your product first, because what happens that once it is gone under production, many times what happened, the court orders that, let's say, for example, the court orders that whatever products that you have should be seized, you cannot sell it. So that becomes an added problem. Okay, any questions? Thank you so much.
Okay. I will just connect. You need this one? I will connect it. I will be able to. Okay. Change this.
I believe most of the people represent different institutions. The keyword is IPR, intellectual property right. Hopefully you all aware about this. Intellectual property right, the keyword. So there are 4 words here: innovation, entrepreneurship, intellectual property, and a startup. Hopefully we understood all such 4 keywords: innovations, Can we differentiate innovation and invention or intellectual property? So there are three words here: innovation, inventions, and intellectual property. Can we able to differentiate all these three words? Again, they are entrepreneurship and a startup. Can we differentiate entrepreneurship and a startup? So all the business, all the startups may be considered under entrepreneurship, but all entrepreneurship are not a startups. Similarly, all inventions are under innovations, but all innovations cannot be inventions.
Reduce this. Okay.
Nowadays, there are so many events and activities on intellectual property rights. Today's World IP Day. So all over the world, there are so many events and activities relates to IP, not on this day, but the whole week. Nowadays, we celebrate IP week because due to lack of resource person, and there are so many institutions, all such institutions nowadays celebrate this IP day. So they have to schedule as per their convenience. So whole week is celebrated. Firms that own intellectual property rights have an average 20% higher revenue. So not only for commercial interest, people are doing such innovations and protecting even individual for their own growth and promotion. Similarly, educational institutions. Nowadays, all the times, AICTE, NEC, UGC ask the data, how many applications you have filed, how many applications you have published, how many applications you have granted, how many of such granted patents you have commercialized, technology transfer. So all the times they need data. So there are some pressure over the person who worked under such institutions. They need to submit data time to time. Sir said in earlier session, Thanda bole to. Similarly, once we say IPR, generally what comes in your mind? IPR means protection. IPR means patent. IPR means copyright. IPR means trademarks. So all such patent, design, trademarks, copyright are different types of intellectual property rights. Rights, legal rights, exclusive rights, so that no one can commercialize such kind of intellectual property without the prior consent of the right holder. So the creator, innovator, that person need to protect their intellectual property. That's why we can say IPR is in connection with protection, legal protection, so that only the right holder can enjoy. And if anyone interested, they need prior consent. Without such consent, if anyone doing such commercialization, that is called infringement. And even if you didn't protected it, still if someone doing such things, that means that person passing their goods or services under someone else brand. So that is called passing off. So there is a difference in passing off and infringement. So other than such keywords like patent, design, trademark, copyright, is there anything else which may be covered under intellectual property right? GI. Anything else? Trade secrets. Anyone else? So right now we have more than 10 types of IPR. More than 10 types of IPR. So we already discussed around 6-7 types of IPR. What else? Biodiversity, traditional knowledge, utility model, layout design of integrated circuits. Sorry? plant varieties. So total more than 10 types of IPR comes under IP region. And that's why we need to protect it. If we don't protect, whatever the efforts, investment, time, anyone else can enjoy if we don't protect it. So awareness for intellectual assets is the key to gaining competitive advantage of technological gain for achieving higher economic growth. So ultimately it linked with commerce, economics, monetization. So not only recognition, it gives monetization. So far what we do, in particular in academia, we publish. Whatever we do some research, innovations, generally we publish it. And that's why earlier Director General of CSIR, Dr. R.A. Maselkar said, publish and perish, patent and prosper. If you publish, maybe you get recognition, but you can't stop others for commercial activities. Or generally academic people don't do any commercialization. So you are doing a spoon feeding to the commercial entities. So anyone can enjoy your research output. So what's your benefit? What's the benefit to your organization? And that's why we need patent protection so that we can do technology transfer, commercialization, and we can share the revenue. And once you get the recognition and the monetization, obviously you will get more motivation to reinvest such monetization for your new ideas, so that you can express such new ideas using your monetization fund motivation, so you can do some efforts. This is recent news, this year only. In January 2025, Supreme Court of India upheld a Bombay High Court ruling that allowed a Dalit couple to receive compensation for the destruction of their intellectual property. This was a landmark case that established that IP damage can be compensated under SC and ST. So actually, the purpose of this news, whatever you write, whatever the data you maintain in your laptops, all such things considered intellectual property. So there is a value. If someone misappropriate such data and information, you can claim under the property law. So even under SC/ST Act, they get compensation for such property loss. Although this is not a tangible property, this is intellectual property. Having some write-up, some data and information in their laptops. So there is a case of theft of their laptop. So they get compensation 127 crore. So this is not a registered IP. This is unregistered. This is in crude form. There is no any final product. This is just the project work, which is still under process. But whatever the efforts that person doing for their project, whatever the data and information they compile in their laptop, they get compensation. So just imagine if you do some successful research output, protect it by registration, how much you can get compensation out of IP infringement. Just imagine, an idea can change your life. So IP rights are the ownership rights. You have over things that you create as a result of your original ideas. So can we protect idea? Can we protect idea? Generally, many times we discuss ideas. Ideas cannot be protected. We need to work on the idea. We need to express our idea. And for such expression, we need some research. We need some time, efforts. And such expression may be considered intellectual property, and if fulfill the criteria of particular IPR like patent or design or trademark, it can be considered under such types of IPR. So see this slide. All I asked was, can I patent my copyrighted trademarks? So most of the IP practitioners have such experience that clients come to them that we need patent for my logo. So there are different types of intellectual property. If people don't differentiate different types of intellectual property, how they can know what kind of intellectual property right they need for their intellectual property? So in single sentence, we can't use such different IPR for the one particular intellectual property. So such intellectual property may be a logo, which may be registered under trademark, may be an invention, which can be registered under patent system, may be a design of any article that can be considered under industrial design. So it depends on intellectual property. Nowadays, there are so many unfair business usage of intellectual property. So we have a specialized court on IP. So far, we have 3 IP benches in high courts, one in Delhi, another in Mumbai, and third one in Calcutta. Recently, head office of CGPDTM, Controller General Patent of Design Trademark, that shifted Mumbai to Delhi, and it becomes highlight. Although there is no any IP office, this is the office of CGPDTM, and all the IP officers comes under CGPDTM. So there is no any issue relates to patent. This is an administrative initiative. For the sake of convenience, because all such IP offices are in Delhi, DPIT, Department for Promotion of Industry and Internal Trade, that is in Delhi, and all such IP offices are under DPIT, and that's why there is a need to shift such office from Mumbai to Delhi. But again, there is a adverse news, unnecessary issues on such shifting of IP office from Mumbai to Delhi. So innovation to a startup. All startups considered entrepreneurship, but all entrepreneurships are not a startup. We have Aadhaar card. Similarly, all MSME may have Udyam Aadhaar. Similarly, all startups may get DPIT recognized certificate for their startup, because there are a lot of benefits out of such startup certificates, and all such certifications are free of cost. Anyone can generate such certifications by using their portal. So new creations and value additions that are useful to the society, they need to be protected. Otherwise, anyone can misappropriate without any consent. No one is willing to share the profit. If such things is protected, no one can do such commercialization without the permission, and for such permission, they need to share the profit. And that's why we need to respect intellectual property right. So exclusive commercial usage, legal monopoly, exclusion. So they are set of exclusive rights. IPR protected innovation, competitive edge to the right holder, monetization of innovation, get paid every time someone reproduce your innovation. Maybe it's invention, maybe a aesthetic design of any article, any goods, brand name, logo, literary item, software. So there is a story. I don't know whether this is fact or not, but many of you might heard that there are so many Nolakha Mandir, there are so many monuments. Taj Mahal is one of such monuments. So many times there is some stories behind that. Those who are the designer, creator, the ruler cut their hands or finger so that no such monument can be replicated. Otherwise, there is no any value later on. Purpose is exclusivity. Ultimate purpose is to exclude. No one can do No one can create, again, such kind of things. But society is so dynamic, system is changed. Nowadays, we have IP legislation. Under this legislation, government gives exclusive rights in the form of intellectual property rights so that you have power to exclude everyone, no matter what's the position of that person. So even Tata, Birla, Ambani, Adani, whatever, if interested in your innovations, they can't commercialize it without your prior consent. And for such consent, it's up to you whether you're willing to give consent or not. If willing to give consent, what's the terms and condition? It depends. So internationally, there is a system over the IPR. We have WIPO, World Intellectual Property Organizations. We have WTO. Most of the countries are member of such organizations. So there is a standard norms internationally. So all the countries, member countries, follow all such norms, but some of countries have some reservation. Like for copyright, internationally, the term for protection is whole life of the author plus 50 years. So no country can reduce this term, but if anyone interested, they can extend the term of protection. Like India gives 10 plus whole life of the author plus 50 plus 10, 60 years. Some country gives 20 year extra protection, whole life plus 50 plus 20, 70 years. Similarly, for other kinds of IPR, they can flexible, they can give more benefits to the applicant, but they can't discriminate. What they are giving to their own nationals, similar treatment they need to give foreigners also. See, WTO TRIPS, under the TRIPS there are 7 IPR, but all the member countries are free. They can add more IPR as per their convenience. Yes, please.
Sir, there is some missing is there, some card is there. And sir, all card have 4 wheels. And suppose I want to make a 6-wheel card. Maybe the card will maybe the blast also, but I have not done any research. I have just designed. It is risky to get the thing.
This is really a good question. See, he is not aware whether his product is useful later on or not, whether there is a requirement to submit such safety clearance before filing the patent application. Might be we are not aware. Just imagine. Particularly if you are talking for the perspective of IPR or patent, then there is no any such requirement by patent office. They don't ask your tangible product. Even there is no need of prototype. Forget the safety features. They need to check only 3 criteria. First is novelty. It's clear, it's novel because so far there is no any such vehicles having 6 wheels. So it's novel, okay. Second criteria, inventiveness. Whether it's inventive, whether it's obvious or non-obvious. So what's the benefit of adding extra wheel? It may be a question. How you can justify adding such wheel may help, may solve a problem which exists earlier, not solved so far. By adding extra wheel, it helps solving that problem. So you have to highlight what's the problem. So this is just like problem solution approach. You have to highlight some problem, then you solve that problem by your inventions. Even you don't have prototype, there is no any tangible product, such application may be accepted. It doesn't mean once you get the patent, you have ability to commercialize it. It depends again. There are different departments. You might need some NOC approval from other departments, but patent office don't bother such. They need only the data and information from you under the patent specification. They have to evaluate based on their database. They have several databases. Whatever the information already in public domain, whether by patent literature or non-patent literature, they checked using the keywords. There are a lot of documents they refer. They cite some of the relevant document in patent examination report. We call FER, first examination report, maybe subsequent examination report. You need to respond such examination report in time. The time limit is 6 months. If they able to convince with your written submissions, then it's okay. If there is still some problem, they may issue subsequent examination report. Might be they give a hearing schedule so that verbally we can communicate during the hearing schedule. And if they convince after the hearing, you need to submit written submission post hearing submission. So on the merit, application may dispose, may be accepted, may be rejected. So anyone can file anything. Filing is not an issue. It's a clerical job. It takes hardly 10 minutes for filing a patent application. And what next? What next? Just after filing, what next? Any idea? Yes. What next? Just after filing. Oh, later on. Just after the filing, what next? Next is the publication. Publication is default. There is no any your role. Just after filing, from the date of filing or the priority, whichever is earlier, after expiry of 18 months, next Friday, your application will publish free of cost, without any cost. Government fee is 1600 rupees. So within 1600 rupees, you will get patent publication free of cost. There is no any cost for publication. If you need, you can request for early publication. No. Whatever you submit the list of inventors, inventor number 1, 2, 3, 4, 5, equal weightage. We get equal weightage in patent publication. This is not like a research publication. I don't know why UGC, AICTE or other bodies for next purpose ask how many applications you have filed, how many applications you have published. For my perspective, there is a zero relevance for publication and application number. There is no any sense regarding the numbers, how many numbers of applications you have filed or published. There is no any importance because anyone can file anything. Only 1600 rupees. If you collaborate with 10 inventors, 16 inventors, you need to contribute only 100 rupees each inventors, 100 rupees only. If we have 16 inventors, 100 rupees is the cost. For filing, publication is default. There is no any human intervention in such publication. No one check the application, a specification, anything. It's automatic. Whatever you submit, anything. You can copy the text from your children's notebook, file the same for patent application, it will publish after expiry of 18 months. Anyone can access. So, is there any sense promoting such numbers? So this is a number game. What is the important? Important is how many applications have been accepted by patent office. And more particularly, how many such patented invention you have successfully commercialized. The purpose is monetization. If purpose is only the recognition, people don't talk for IPR or patent. Better what we are doing earlier, publication. So publication is more costly nowadays and there is no any commercialization out of such publication. Better we file a patent application, less costly, and there is a scope for commercialization also. And nowadays, there is a huge FDP, there is huge funding in abroad. There are more than 10 ministries promoting IPR. More than 10 ministries. Just imagine how many departments, how many offices, there are how many schemes that are promoting intellectual property rights. There is huge funding in billions, not in million. Huge funding. There is award and reward at every step. on the number of applications, on the number of publications. Even if you commercialize successfully, you may get huge amount out of commercialization. Again, government giving you big rewards, monetization, so that there will be a message to the other. If they do some efforts for technology transfer, commercialization, they may get such award. So there are multiple benefits out of single application. And most of the startups have only one invention. And based on their inventions, they get success in their startup. Just imagine the case of Nobel Prize. There are 7 Nobel Prize, I think. 5 to 7 in around. Each Nobel Prize have certain money. What is the source of all such? There is a fund reserved in Swiss bank. Whatever the interest every year, that is distributed for such Nobel Prize. So what is the source of that deposit? That is the dynamite. Alfred Nobel patented dynamite, the chemical. See the commercial earning at that time, a fraction of that profit he deposited, so that whatever the interest out of that fraction of deposition profit given to those person who do some work in public interest. So only one patent have so much power. Just imagine if you have multiple inventions, multiple patents, successful technology, successful inventions, having commercial viability, there is a demand in market. Just imagine, such idea can change not your life, your family life, your country life. So this is the system in India. We have patent office, trademark registry, GI registry, copyright office, layout design of integrated circuit office. There is a headquarter, there are branch offices. Nowadays, people don't bother where is such branches, how many branches, where is the office, because everything is online. We can file such application online. We can attend the hearing online. Disposal is online. All the certificate issued only online. There is no any hard copy issued nowadays. These are the certifications: patent certificate, design certificates, copyright certificates. This is the portal. There is a single portal, ipindia.gov.in. All the IP linked with the same portal, IP India. See, there is a comprehensive e-filing. Comprehensive e-filing. Once you click, there is a e-filing patent, e-filing trademark, e-filing copyright, e-filing industrial design. So you can file e-file. For the e-filing purpose, we need either e-sign or digital signature. Anyone can create account here. There is no need of attorney's agent, but it's not recommended, because if there is a communication, obviously there is a communication between the applicant and IP offices, and this is time bound. We have to respond in timely manner. So in lack of prosecution, our application may abandon. So there is no any benefits of filing such application. And we can't refile the same application. Although we can file the same application after abandonment, but there is no any benefits. Why there is no any benefits? If somehow our application abandoned, why we can't refile the same application? Or if we file the same application again, why such application cannot be considered by IP offices? Although we are paying, again, they also prefer numbers. So number of application at least they can recount. But no IP offices considered such re-applications, not refine, re-application. So So there are three criteria: novelty, inventiveness, and utility. First criteria, novelty. If we file application have to be published. Once your application published, later on application abandoned, maybe due to any reason, if you refile the same application, there is no novelty. You can't prove the novelty. Your own application, your own publication, novelty is considered worldwide. So no matter where you are filing, anywhere in the world, if someone or you yourself have filed such application already published, or not the patent application, even if there is any news, any articles, any such research publication, even if there is no any publication, if there is any use, that means the subject matter, the inventions already in public domain. So if things is in public domain anywhere in the world, it is not considered novel. There is no any novelty, newness. So we already discussed copyright, trademarks, JNU. What do you mean by JNU? JNU. Jaipur National University, VIT, Vivekananda Institute of Technology. So guess what it is? What is this? So just imagine the power of the design, aesthetic design of any article. So suppose this drawing, just imagine this is a drawing. There is no any real article. There is no any real goods. This is just a sketch by using paper and pencil. See the commercial value of such sketches. Can you protect it? If we can't protect it, anyone can use it for their goods, for their articles. So we need to protect it because there is a commercial viability. There is a scope for trade and commerce. We can register it under some sort of intellectual property rights. So this is intellectual property. So this intellectual property under which IPR we can protect? Design. Why not for copyright? Can't we protect it under copyright? Copyright is for software. Okay, see, software. Software is the subject of innovations, intellectual property, which can be protected by patent also. Many countries give patent protection for the software. India don't give patent protection per se on the software, but if you club software with some machine, some tools, some device, some gadgets, we can claim such gadgets, such device under the patent system without focusing on that word software. Actually, whatever the function of that device, that is just due to the software, but we can't claim software under patent system. That's why we do such manipulation in India or in some other countries also. And those countries where it's considered for patent, there is no any problem. Again, these sketches, under copyright, there are different subjects matter. Like sir already discussed, literature, drama, music, artistic things. So it may be considered under artistic, isn't it? Paintings. So there are so many subject matter which can be covered under copyright. So this may be protected under copyright. And another one is industrial design. So what's the difference in copyright and industrial design for the perspective of such sketches? How we prefer, whether we should go for copyright or we should go for industrial design? Any idea? Marketable. Markable. Yes, we can protect the same thing under multiple IPR, but different aspects of the same thing can be considered under different things. Just like laptop. See the logo, the mark over the laptop. That is a brand, HP. So HP is considered for trademark, but the look of this laptop, the aesthetic design, the color combination, that is protected under industrial design. Again, the software, the technology behind that, that is protected under patent system, technology. The advertisement, the write-up, the specification of the laptop, protected under copyright. Integrated circuits, the design of such integrated circuits comes under layout design of integrated circuits protection. Same article, same goods, same products, there are multiple aspects of the same thing. All such different aspects may be protected under different kinds of intellectual property rights. In the mineral water bottle, the design of that bottle under industrial design, the grip, functional aspects protected under patent system, the quality of water inside, the source of water may be registered under geographical indication, formulation may be under patent system, the wrapper, the content, literary things may be considered under copyright. The same things, the different aspects of the same article may be protected under different kinds of intellectual property rights. See the chair. One costs 700, another costs 2000, another one is 4000 rupees. Which chair you prefer? There is a cost there. There is a tag, price tag. Which chair you prefer? It depends person to person, their choice. Although the function is same. So this is the design only which need to be protected under this chair system because there is no any patent. Maybe there is earlier patent expired, now anyone can use it, but no one can claim patent rights. Everyone are free to use their patented invention which has been expired. They need to innovate, so they need to differentiate their chair. So there is a color, there is a design, so that they can innovate the existing articles, existing things. So we need to protect it. Otherwise, anyone can use copy of other innovative articles. See the difference? There is hardly any cost involved in such design matters. Isn't it? Hardly much cost involved in such design matter, but see the cost. One is generic one. Anyone can purchase such generic articles, put their design, so they can create exclusivity. No one can commercialize without their prior permission, those who are the right holder. So it takes hardly 5% in the cost regarding the design. It affects the public decision, user decision. So there is no any functional aspects related to design, only the aesthetic appeal of that design. See, what is this? Long back, once it exhibited in Delhi, Pragati Maidan, now Bharat Mandapam. So this is a toy, yellow colored, toy. Do you think there is any conflict, any IPR issues? See the target. There are different kinds of buyer. The target is different for toys and real car. Do you think any conflict here? What the conflict? design. If we focus on the design thing, it covers the shape, not the size. It's the shape, not the size. Visual, look, appeal, aesthetic appeal, the design part that covers the shape and design, shape and color, not the size. So without prior permission, no one can use such design, even for the toys. Just imagine the commercial aspects of such design curve. How many interested to purchase? No one. So this is half cup tea. It is design. So this is funny. So regarding GI, see the status. So far we have around 1500 GI applications in India, and more than around 50% applications has been registered, less than 700 till yesterday, 25th April 2025. 2 years back, the data is around 50% only. So within 2 years, there is a huge acceptance. Many hundreds applications has been accepted in last 2 years. And recently, in one meeting, Piyush Goyal asked how many applications of GI is accepted in China and in some other developed countries. He noted around 10,000. So he suggested if they have 10,000 GI, we must have around 20,000 GI, around double. Because there is so much diversity here in India. There are so many handicrafts items here in India. There are so many different kinds of fruits, vegetables, recipes. So there is a potential here, and we must be vocal for local. So there is a great opportunity nowadays if we work on the GI point of view. For academicians, we people may help in documentations for GI purpose. And GI is only IPR which is different than other IPR. Like anyone can file any IPR like patent, design, trademarks, but for GI, only the society. No individual can file GI application. So this is society rights. So we can help in documentations, evidence. So what kind of items may be considered under GI? So it may be a food item, handicrafts item, textile item, natural item. So there are different kinds of things which can be considered under GI. Bhujia. Once we listen this word bhujia, what comes in our mind? Haldiram. So this is a brand. Haldiram. Haldiram is a brand. Bhikaji. This is another brand. What next? Bikano. This is third brand. Bikano bhujia. Haldiram. Bikano. Bikaneri bhujia. This is not a brand, Bikaneri bhujia. Bikaneri is a generic word. That means this bhujia originated from Bikaner. So all such Bikano, Haldiram can use this word Bikaneri so that they can show that their bhujia is made in Bikaner. So anyone are free to use this word Bikaneri, but subject to whether the source is really Bikaner or not. If such manufacturing is not in Bikaner, then this is deception. You giving wrong information to the user that your product is manufactured from Bikaner. So if this thing is really manufactured from Bikaner, then you can use bhujia made in Bikaner. You can use this line, bhujia made in Bikaner. But Bikaneri bhujia,
Sir, if Rasgulla get GI tag, then what will happen?
I'm come to that point. Once we clear this bhujia issue, bhujia and rasgulla. Okay, very nice. So anyone can use bhujia made in Bikaner if their bhujia originated or manufactured in Bikaner. No problem. But Bikaneri bhujia is a GI tag. Bikaneri bhujia is a GI tag, like Gamcha of Assam. This is also a GI registered. All such people, Bikano, Chandmal, Bikamal, all manufacture their bhujia in Bikaner. So they write bhujia made in Bikaner or in Bikaneri bhujia also. So there are three words here. Their brand's name, Bikamal, Chandmal, whatever. Another thing is Bikaneri bhujia, and third thing is bhujia made in Bikaner. But there are many people who doing such manufacturing. They are using their brands. They are using that line bhujia made in Bikaner, but they can't use Bikaneri bhujia. Why they can't use Bikaneri bhujia? Although the quality may be excellent, may not be substandard, they are manufacturing that bhujia since generations, maybe from the Bikaner itself. Still they are not qualified to write this expression, Bikaneri bhujia. Why? So all Bikaneri bhujia are made in Bikaner, but all made in Bikaner bhujia are not Bikaneri bhujia. Why? This is the concept of GI, geographical indications. Only the authorized user under that society can use such GI tag. Those who are not the member of that society can't use such GI tag. Muga silk from Assam. Only those persons who are the member of that GI society. Unfortunately, there is no any such GI society because there is so many GI society, Muga society in Assam. So everyone will fight. No, it's our product. No, it's our product. So in public interest, it's a government body, AICTE. They file this application, and the registered body head is AICTE, Assam Science and Technology Institution. So there is no any Muga silk society here, although there are so many societies. So all those are the member, they can use such GI tag, Muga silk of Assam. Those who are not the member, they can sell Muga silk, but can't use this expression, Muga silk of Assam. Maybe many people are using such expressions. This is just due to lack of awareness, number one, and number two, due to lack of implementations of IPR laws, because no one is aware. Even advocates, judges are not aware about IP legislation very well. So there is no much litigations in the field of IPR. Particularly for GI, this is in public interest. For grassroots people, there is hardly much litigations. Although many times we cry, people are doing such manufacturing in Surat, Bhagalpur, for Muga silk, they are offering such products in 500 rupees, although the real product is accessible in more than 50,000 rupees for each sari, and similar design, similar color sari is available in 500 rupees or even less than 500 rupees. See the difference, 500 and 50,000. These are not authentic, and those who are purchasing such things, they know very well this is not authentic. How a real products which cost more than 50,000 rupees may be available less than 500 rupees. So there is no any infringement. So there is no any market capture. Problem arises once there is a confusion. Is there any confusion? There is no any confusion. Regarding Rasgulla, what happens? West Bengal filed application for GI for their Rasgulla. At that time, people are thinking Rasgulla, the source of Rasgulla is West Bengal. But at the same time, there is opposition from the Odisha. So Odisha said, no, we are the first manufacturing Rasgulla in India. So either no one may get it registered, and if there is a registration must be in our name. This is very interesting case for the study point of view, so that we can understand the importance of GI. Anything can be registered in the name of multiple places, like rice. Rice, you can, orange. There are so many things, there are so many handicrafts items which are registered in every state in the name of their own geographical area. More than 20-30 kinds of rice is registered under GI from their local areas name. So there is no any confusion. Similarly, they registered such Rasgulla in the name of West Bengal and in the name of Odisha. So there is no any problem, because there is a different quality. Even quality is same, there is no any confusion, because everyone is promoting their products in their name, not in the name of others. So in the name of West Bengal, if you are promoting your Rasgulla, no problem. And Odisha people can't use West Bengal name for their Rasgulla. Similarly, West Bengal people can't use Odisha name for their Rasgulla. That's all. So anyone can file such applications, but restricting the indications with a particular geographical area, so that there is no any conflict with others area. No, that is the brand name. These are the brand name, because this is not an individual rights GI, this is a society rights, and that's why most of such applications comes from the particular geographical area, and such geographical area name is a GI tag for that products. There is some more slides which is very useful to you. If you're interested, we can continue like some IPR schemes. See, this is the life cycle. Life cycle includes from ideation. We need to work on the idea so that something may be created, or whatever the creations, we add certain value in the existing things. Once we create something successfully, we need to protect it. Protection is territorial. So we need to explore where there is a market. Accordingly, we need to protect such things in different countries. But it's too difficult to register your innovations in multiple countries. Suppose more than 250 countries, you need to protect your thing. And there is a deadlines, like within 12 months, within 1 year, you need to file applications in all such countries. So there is a problem regarding language, regarding currency, regarding local address. You need to hire one IP attorney in all such countries. So there are different countries, different IP offices, different documentations, different currencies, different agent. So it's very difficult for any person to pursue their applications in multiple countries. And that's why there is a system of international application. There is a system of international application, so that at least you can file application provisionally, and there is an adequate time to complete it. Right now, suppose we have 12 months. So it's too difficult to complete all such things within 12 months. But under international filing, generally we get around 30 months. So there is enough time to enter in countries of your choice. After registration, we need to maintain it by renew annuity. Every year you need to pay, like in patent, you can do renewal for 1 year or multiple years, but for design there is only one time renewal. After 10 years, we can renew it once for 5 years. So maximum term of protection is 10 plus 5, 15 years. For trademarks, GI, we can renew it perpetually after 10 years. So we have IP policies. Under that IP policies, there are 7 such points. Regarding the government fee, for small entities including individuals, startups, MSME and educational institutions, there are 80% discount. There is 80% discount, and this discount applicable to educational institutions only from last year. Earlier they need to pay 5 times. And that's why since last year, there is a huge filing from the academia. And this is not only one ground, the cost. Another ground is the number, how many numbers. And again, you get the benefit of publications, patent publications, although these are not as part of the research publication. And that's why there is a huge filing from the academia. Earlier, there is hardly much filing from the academia. If we talk about the number of technology transfer, then you may find the real picture. How many academic applications is successfully commercialized. So filing is not enough. We need to pursue it. We need to request for examination. Otherwise, our application will abandon. Earlier, the deadline for examination is 48 months. Now it's reduced to 36 months. So whenever there is a talk about the disposal of patent, it takes around 4 years, 5 years. Minister forced to such IP office reduce such timeline so that it may be disposed sooner. So most of the times what happens, government office reduce timeline for we people, not for them. Are you getting this point? If we need to respond patent office within 1 year, they reduce this timeline 1 year to 6 months. So there is a pressure on you people. Again, if we have option to request for examination within 4 years, if they are reducing 48 months to 36 months, so every time the reduction is for we people for the disposal of the application, but they are silent about their disposal. Once we file the application, how much time they need to examine? Once we attend the hearing, how much time they need to dispose such application? Are you getting that point? So for early publication, the government fee is 2,500 rupees. So this is optional, so that your application may be published within 1 month. And no examination will happen until the publication. So if you need early disposal of your application, you need to request for early publication, so that your examination will continue just after the publication. So request for examination, the cost is 4,000 rupees. So total cost is, without option, early publication 5,600, and with early publication the cost is 8,100 rupees. This is the government fee. Under the AICTE Kapila scheme, they are reimbursing 10 patent applications every year from the academic institution, reimbursing the government fee. Now they increase 10 to 100 applications. All such academic institutions may file up to 100 applications. All the government fee will be reimbursed under the Kapila scheme. Zero cost. Now, professional charges. Professional charges. So there is a scheme of SIPP. SIPP is for a startup. Educational institutions cannot be considered under the startup. But there is an extension of SIPP scheme. What is the extension? The TISC, T-I-S-C. This is the certificate from DPIT for the startup, certificate of recognition under Department of Industrial Policy and Promotion. Earlier the name is DIPP. Now it's a DPIT, Department for Promotion of Industry and Internal Trade. So under the SIPP scheme, there is 80% rebates to patent and design, 50% discount to patent trademarks. There is an option of expedited examination and disposal. government bear entire cost of facilitator. So under SIPP scheme, there is a scheme of facilitator. There are so many facilitator around, I think more than 600 facilitator around. So anyone can get free service of such facilitator. You no need to pay any single penny for professional charges. So government fee reimbursed under Kapila scheme. Professional charges you no need to bear under this startup, but they are served under SIPP scheme, and being an academician or academic institution, they will not waive off their professional fee. So there is an extension of SIPP, that is WIPO Technology and Innovation Support Center. Nowadays in India, there is around more than 10 TISC center. If you approach such TISC center, they will arrange such facilitator without any cost. So again, the same facilitator who serving under SIPP scheme, they will help you to facilitate your patent application without any cost. So there is a MSME scheme. So they also award reimbursement after the disposal of your application. So for foreign patent, they gives 5 lakh. For domestic patent, they gives 1 lakh rupees. For GI registration, 2 lakh, and design registration, 15,000, and for trademarks, 10,000 rupees. It is noted that due to lack of adequate awareness about such schemes, very few applications received by such MSME offices. So there is hardly much applications received for reimbursement. So if you interested, you can get benefits of such schemes, reimbursement, funding. So ultimately, there is a zero cost for patent. Government fee reimbursed under Kapila, professional charges you no need to bear under TISC scheme. So ultimate cost is zero. Long back in year 2016, UGC wrote a letter to all vice chancellors in India. See the second paragraph. Keeping in view the importance of IPR, which recognize the work of the creator, you are requested to devise through Academic Council inclusion of CBCS scheme one paper on IPR. So most of the institutions have one optional paper on IPR, 100 marks. Many times there are some challenges for the resource person. So under NIR ranking, there are some marks distributions for filing, 2 marks for publications, for granted 4 marks, and for license 4 marks. So please feel free to ask if you have any questions relates to any of the IPR. There is a huge career opportunities. I suggest you must recommend career in IPR to your students, your researchers. There's a see, in order to monetize, you have to establish there is a utility. There is a utility. If there is a utility, if there is a demand, if there is a market, you can promote it so that the person who may interested to commercialize your product may get license or assignment from you, so that it's up to you whether you interested to establish your startup or you interested to assign someone or license someone your innovations. Many times it is easy to do such commercialization technology transfer once you registered it. But there is no any restrictions, you need to register it. Even without registration, you can do it. Many times people succeed to commercialize by means of licensing or assignment before the patent. And patent applications filed by that companies only who purchase such innovations from you people. Or suppose if you already filed the applications And during the pendency of such patenting, if you succeed to commercialize such IPR to someone, someone may request you, they are willing to pay lump sum amount, please assign your rights so that they can update the records. So under Form 16 of the patent, they can get updates in the name of applicant. Although inventor's name can't be changed, but the applicant name can be changed. So you can, in order to commercialize, in order to succeed the startup, you have to focus over the utility part of your innovations. And if you promote such things, if there is a utility, obviously, some person who are interested, who are dealing in the same kind of things, they may get negotiation to move further. So it's up to you whether you start your own startup or you're willing to give license to someone else. So regarding the job opportunity, if you use any of the keywords like patent or whatever your subjects in the field of science, like biological science, chemical science, physics, with the help of these keywords only, you may get link of IP opportunities not only in industry, but in LPO, KPO. There's a huge outsourcing of such IP work in India nowadays. Market is worldwide. All such things is online. People are making huge money from their home doing such IP services online from their home. So there is a great opportunity. We must promote such things in our academia so that, please. Nowadays, I don't think people are downloading from other sites. They are using ChatGPT. There are so many other options. I think better option. So don't worry about such copy and paste regarding the study material. We need to innovate it, continue. So better restricting, better we need to add value. So there is ample scope to add value to in existing literature. No problem. There is an option, copyright. You can file the copyright suit, no problem. Already we have options. Whatever we publish, there is a copyright. There is a default copyright. No need to file application for copyright. It's a default. You need to establish the date of publication. Anyone may copy once you publish. So that person can't establish the date prior to your date. Isn't it? So best option, rather than filing copyright application, whatever you write, submit to yourself by post or email so that there is a date and time. Only after creation such things may be theft. So no problem. How other person who doing such copy theft of others' data, can they establish that prior to your date? So no problem. It's free of cost. You can enjoy copyright protection in your creation. If someone downloading, you can sue. Better, before filing the legal suit, you can give a legal notice, or not a legal notice, a polite notice. A simple email, you can notice him that this is your copyright material. You already own the rights. The date of publication is so and so. Whatever you are doing publication, this is around 100% or 90% or 80% is similar to your publication. So this is copyright infringement. So please take it down. Otherwise, you may initiate legal proceedings. So most of the times people take away such material from their portal. So there is already solution for such type of problem.
If we file the patent, it is published.
Yes.
How much time it will take for a patent to be done?
Minimum time is 6 months. There are some cases which is disposed in 6 months, disposed positively. Certificate has been issued within 6 months. There is no any upper limit.
So is there any process to
Yes, for the startup, you can request expedited examination. So it may be little faster. But for ordinary application, there is no any option to fast it. I request at the time of filing, file the request for early publication, file the request for examination, don't delay it. And if there is an option for expedited examination, request for expedited examination. So most of such things may be disposed within 2 months. Otherwise, it may take more than 2 years. So you have options to reduce 2 years. Tentatively 2 years, you can reduce it. Otherwise, it may take maybe more than 2 years. And once you receive the examination report, there is a timeline 6 months to respond. Why to wait for 6 months? Within 1 week, you can submit. So you can reduce again 6 months. Again, after the hearing, you can submit the same day, whatever you argued during the hearing. No need to delay the submission. So many times we have options. We need to submit the documents, information. So there is a deadline. No need to wait to exhaust the deadline. Unnecessary delayed from our end. So at least you can save that time. But we can't control IP office, patent office. If there is a provision for expedite, we can do it. So I suggest request for early publication, request for expedited examination, so that at least 2-3 years we can save. So 2-3 years may be saved from the government office on our request, and later 6 months we can save. As soon we receive the examination report, within a week we can share the response, and just after the hearing, maybe within 24 hours we can submit the written submission. So unnecessary we can't delay. So it's not the office only, it's we also include, because there are different parties. Applicant, first of all inventor, then applicant, then IP attorneys, the agent, and lastly the patent office. So this is the only option to save the time, to expedite it.
There is no maximum time.
No maximum time. It may be more than 20 years. So within 20 years, patent lapse. So there is no any benefits of having patent at the time of expiry. Again, we need to renew our patent rights after 2 years. Suppose we get patents after 10 years. We need to pay renewal fee from the 3rd year onwards, 3rd year to 10th year. We need to pay unnecessary 8-year renewal fee. This is nonsense. We didn't have patent rights and we have to pay renewal for patent rights for those years. There is no any patent issued. Why we need to pay renewal fee? So there are so many nonsense is going on. Problem is people are not aware. They are not speaking for their rights. IP attorney don't have time and they don't have any interest to fight with patent office. It's very few people. Yeah, counterproductive. I'm from DPIT. All IP officers are under DPIT. I'm also a patent agent. But they are different source of revenue. So some people don't have any fear. And that's why very few times you heard such type of things, that there are so many loopholes, there are so many rubbish things. Unfortunately, no one have time to think about such things. Otherwise, see the patents, it's so important, so important. Many developed countries dispose such patent application within 6 months. At least in 1 year, we have to dispose such patent applications. And see the attitude of controllers and examiner. If you file some application, request your patent agent, IP attorneys, you are also interested to attend the hearing. Since hearing is online, no one is going IP offices to attend the hearing. So just ask the link so that you can join. Just see what is going on. Sit idle, no problem. If you like to interrupt, you can raise your voice. No, your invention is so and so. This objection is not valid. If you have some response, you can share your expressions. You can note down what is going on, so that after the hearing you can submit your point of view. So we must attend such hearing, and there is no any limitations. At least all the inventors can attend, no problem. No matter how many inventors. So if you have patience and time, I can continue, because these are the tips of iceberg. It's nothing much. Time is over. Okay. Thank you very much. I didn't share the most important slides on patent. I discuss only some schemes, basics of IPR, and these are the tips of iceberg. Because most of the times, if we start directly on patenting, drafting, the different steps, how we may follow up, it may be little boring for many persons. So we prefer discussing on such things once we have understanding about different kinds of IPR, and if we have interest, we can continue. Otherwise, there is no any point to continue on such drafting, searching. So thank you very much for your patience hearing. Thank you.
I thank Dr. Pankaj Kumar sir and Manas Burman sir for this knowledge-filled session. Now I request our respected faculty members to join our respected resource persons for a group photograph. And quickly after the group photograph, we move for a quick campus tour, and then we proceed for lunch. Thank you.
मैंने नोटिस किया है, मैं आपको इनपुट देता हूँ, आगे के लिए आपके लिए अच्छा रहेगा.
यहाँ पे दे दो